The clerk will distribute the amendment to all members. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 9598 is offered by Mr. Biggs of Arizona.
Without objection, the amendment is considered as read. I reserve a point of order. The gentleman from Arizona is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I thank you and the ranking member for your work on this bill. The Biden-Harris administration has facilitated the worst border crisis in history. Since January of 2021, more than 10 million aliens have entered the country illegally and encountered Border Patrol, have been paroled into the country under the administration's abusive authorities under the INA, or are gotaways who evaded Border Patrol entirely when illegally crossing between ports of entry. And in fact, in the last 16 months, just reported this morning, the CBP One app has allowed 813,000 individuals to come in and be distributed into the country. And also on the Haiti, Nicaragua, Cuba, and Venezuela program, 530,000 plus illegal aliens have come in that way and been released into the country. This legislation ensures that the ONDCP, which leads and coordinates the nation's drug policy and administers drug control programs, is properly focused on mitigating the deadliest part of the border crisis, the fentanyl overdose epidemic. Overdose deaths remain at record highs. In 2019, roughly 70,000 people in the U.S. died of an overdose. In 2021, that number rose to over 106,000. In 2022, over 111,000 deaths. And in 2023, overdose deaths remained over 100,000, with over 107,000 Americans dying of an overdose in that year. One of the major programs administered by ONDCP is the High-Intensity Drug Trafficking Areas, or HIDA program. Arizona's HIDA was established in 1990 and works to facilitate and enhance drug control efforts across 83 federal, state, local, and tribal law enforcement agencies working in 9 of 15 Arizona counties. This coordinating work is indispensable as law enforcement seek to stop the flow of illegal drugs into the country at and between ports of entry and to make seizures before drug traffickers reach major metro areas and highways in the interior of the country. The Arizona HIDA Task Force plays a crucial role not only in drug interdiction but in building cases against drug traffickers. In fact, earlier this year, the Homeland Security Investigations announced the extradition and indictment of Rodrigo Paez Quintero, Mexican national who faces charges related to at least 9 drug trafficking events from the Lukeville Port of Entry through Ajo and up to Phoenix. That release, and I've got the release here, and I'd ask to be admitted to the record.
Without objection, so ordered.
Thank you, Mr. Chairman. And that release specifically credits support from the Arizona HIDA. It's critically important that law enforcement properly use tools at their disposal when conducting investigations and building cases against drug traffickers. Failure to do so jeopardizes the government's ability to successfully prosecute defendants, allowing drug offenders to go free, and may violate the constitutional rights of Americans. My amendment adds language to the base text of the bill to remind ONDCP and its grant recipients of their obligations under the Fourth Amendment to the U.S. Constitution. In 2018, the Supreme Court held that the government's acquisition of cell site location information constituted a Fourth Amendment search. And last year, Senator Ron Wyden, who I work with occasionally on these issues, and he is, I remind people, sits across the aisle from me, but we work on these issues. He revealed the existence of an ONDCP-funded program whose 2014 promotional materials claimed the ability to obtain cell site location data and allowed information to be obtained by law enforcement without a warrant or court order. As a result of this committee's investigation into the program, I'm satisfied that the program is currently in compliance with the Supreme Court's finding in the Carpenter decision. However, I believe that this amendment and the reporting requirements included in base text of the bill are necessary to ensure that America's Fourth Amendment rights are protected and that the government is able to successfully prosecute drug traffickers. Thus, Mr. Chairman, the purpose of the bill, and I yield back.
Gentleman yields back. Do any other members seek recognition? Chair recognizes Ranking Member Raskin.
Thank you, Mr. Chairman. I just have a couple questions about this, and perhaps the gentleman from Arizona would be willing to just indulge me a couple of inquiries about it.
Yes, Mr.
I mean, it seems commonsensical and intuitive that any program that gets money under this section shall be conducted in a manner consistent with the Fourth Amendment. I'm just wondering about the negative implication for all of the other programs that we've adopted where we don't have language like that. And And it seems a little bit curious to me that we would say this program shall be conditioned on compliance with the Fourth Amendment, but none others. And similarly, what about the Second Amendment, the First Amendment, the Eighth Amendment, the due process and equal protection under the 14th Amendment? Wouldn't we say that it's implied in everything we do that it must be consistent with the Constitution?
Well, thanks for the question, and I agree with you that we certainly would hope that every government agency, from local on up to the feds, would always adhere to the constitutional constraints that it has. But I will just point out a couple things. First of all, the language that we have here is language we've taken from other surveillance programs as well. And so it's not entirely unique. But secondly, I would remind the gentleman of the FISA program where we sought to invoke the warrant requirement, and it failed on a 212-212 vote. And that was largely not the vote itself, but the move to have a warrant requirement in FISA, which, by the way, we would just assume. I mean, just naturally you would say, of course they're going to follow the Fourth Amendment, but they weren't. They weren't following it, and so that's why we wanted to specifically throw that warrant requirement into FISA. And I think that's whenever we have surveillance programs, that we probably want to remind our actors who we are delegating authority to and funding, that we expect them to adhere to the Fourth Amendment and other constitutional provisions.
Mm-hmm. Well, I appreciate that. I remember the debate about the warrant requirement in FISA because that was a case dealing with evidence that was already within the property and possession of the federal government. And so there was ambiguity about whether the warrant requirement needed to be observed in that case. And so there was an effort to impose it when the courts had said a warrant requirement wasn't necessary. Here I think it's stating the truism that the Constitution shall apply against what the government does. I agree with it completely. I'm just worried about, pasting it onto one piece of legislation and not every piece of legislation. And I don't know whether we want to get into the habit of saying everything that the government does should be consistent with the Constitution, or whether that's unnecessary. So I appreciate very much the gentleman's response, and I'll think about it some more.
The ranking member, you?
Yes, by all means.
I thank the ranking member. I would be supportive of continuous endeavor by this committee as we consider legislation that would affect law enforcement operations across the country by grant provision. I would encourage and be willing to participate in ongoing endeavors by this committee to remind our law enforcement agencies that the modern phenomena of violation of Fourth Amendment rights is real, that we have noticed the injury has been significant, and we insist that if you draw money from this legislation that's born of this legislation or born of that legislation or born of the next, we will be watching very closely that your agency complies with Fourth Amendment guidelines. So the ranking member's question was, why would we put it on this legislation and not many others? I might suggest that moving forward, we do indeed add Fourth Amendment language to many bills that we consider, and I yield back.
Great. I would submit for the gentleman from Arizona's consideration the possibility of adding the Fourth and 14th Amendments to include due process, and I suppose, it improves the point, but consider that, and I'm happy to yield back.
Gentleman yields back. Chair recognizes. I'll recognize myself. I want to thank Mr. Biggs for offering this amendment to ensure the privacy rights of Americans are protected. The High-Intensity Drug Trafficking Areas Grant Program, as reauthorized by the bill, funds strategies developed and implemented by coalitions of federal, state, local, and tribal law enforcement agencies
to counter illicit drug trafficking. This amendment will require any such program or activity that receives funds made available through HIDA program to be conducted in a manner consistent with the requirements of the Fourth Amendment to the Constitution of the United States, which protects Americans from unwarranted search and seizure. I support my colleagues' well intention and its inclusion in the underlying bill. Do any other members seek recognition? Seeing none, the question is now on the amendment offered by Mr. Biggs from Arizona. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it, and the amendment is agreed to.
I have another amendment.